My name is Kumar, Akashanand, legal intern in LEXIS and Company. In the previous video, I have discussed section 166 of the CRPC. Now let's see section 167, where procedure when investigation cannot be completed in 24 hours. It says whenever any person is arrested and detained in custody and it appears that the investigation cannot be completed within the period of 24 hours fixed by the section 57, and there are grounds for believing that the accusation information is well founded, the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, shall forthwith transmit to the nearest judicial magistrate a copy of the entries in the day hereinafter prescribed relating to the case, and shall be at the same time forward the accused to such magistrate. The magistrate to whom an accused person forwarded under this section may, whether he has or not jurisdiction to try the case, from time to time authorize the detention of the accused in such custody as such magistrate thinks fits, a term not exceeding 15 days in the whole, and if he has no jurisdiction to try the case to commit if for the trial and consider further detention unnecessary, he may order the accused to be forwarded to the magistrate having such jurisdiction, provided the magistrate may authorize the detention of the accused person otherwise than in the custody of the police officer beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so, but no magistrate shall authorize the detention of the accused person in custody under the paragraph for a total period exceeding 90 days where the investigation relates to the offences punishable with the death, imprisonment for life, or imprisonment for a term of not less than 10 years, and 60 days when the investigation relates to any officer, and on the expiry of the said period of the 90 days or 60 days, as the case may be, the accused person shall be released on bail if he is prepared to and does furnish bail, and every person released on bail under subsection shall be deemed to be released under the provision of chapter 33 for the purpose of this chapter. The magistrate shall authorize detention in any custody under this section unless the accused is produced before him. The magistrate of the second class not especially empowered on the behalf of the High Court shall authorize detention in the custody of the police, notwithstanding anything contained in subsection 1 and subsection 2. The office in charge of the police station or the police officer making the investigation, if he is not below the rank of a sub-inspector, may, where judicial magistrate is not available, transmit to the nearest executive magistrate or whom the power of judicial magistrate or metropolitan magistrate have been conferred a copy of the entry in the diary hereinafter prescribed relating to the case, and shall at the same time forward the accused to such executive magistrate, and thereupon the executive magistrate may, for the reason to be recorded in writing, authorize the detention of the accused person in such custody as may think fit for a term not exceeding 7 days in the aggregate, and on the expiry of the period of detention so authorized, the accused person shall be released on bail except where an order for further detention of the accused person has been made by the magistrate competent to make such order, and where an order for such further detention is made, the period during which the accused person was detained in the custody under the order made by the executive magistrate under the subsection shall be taken into account in the computing the period specified in the paragraph A of the provision subsection 2, provided that before the expiry of the period aforesaid, the executive magistrate shall transmit to the nearest judicial magistrate the records of the case together with the copy of the entries in the diary relating to the case which was transmitted to him by the office in charge of the police station or police officer making the investigation, as the case may be. The magistrate authorizing the section detention in the custody of the police shall also record the reason for doing so. The magistrate after the chief judicial magistrate other than the chief judicial magistrate making such order shall forward a copy of the order with the reasoning for making it to the chief judicial magistrate. If in any case triable by magistrate, as in summon case, the investigation is not concluded within a period of the month from the date on which the accused was arrested, the magistrate shall make an order stopping further investigation into the offence unless the officer making the investigation satisfies the magistrate that the special reason and in the interest of justice the continuation of the investigation beyond the period of 6 months is necessary. Where any stopping for further investigation into an offence has been made under subsection 5. The session judge may, if he is satisfied on an application made to him or otherwise that further investigation into the offence ought to be made, vacate the order made under subsection 5 and direct the further investigation to be made into the offence subject to such direction with regard to bail and other matters may be specified. Thank you. See you in the other video.